So there are lots of developments out of Georgia today, where Donald Trump and 18 other co-defendants are being accused of being a part of a criminal racketeering enterprise to overturn the results of the 2020 presidential election in that state. Two co-defendants, Ken Chesebro and Sidney Powell, have already requested a speedy trial. And that request has been granted. Their trial is set to begin on October 23rd. But the other defendants, including former President Trump, do not want to move that fast. Last night, soon after DA Fani Willis filed a motion saying all of the defendants should be tried together because the same evidence and the same witnesses are being used against all of them. After that, last night, Donald Trump filed a motion waiving his right to a speedy trial. In exchange, he is asking to be tried separately from the other defendants. Now, this doesn't necessarily mean that Trump is merely looking to separate his trial from everyone else's. It could suggest that Trump is attempting to avoid a speedy trial at all costs. At least 5 other co-defendants filed similar motions today, with many of them saying they also won't be ready to go to trial by October 23rd. And all of this is turning into a kind of logistical nightmare, the very kind that prosecutors usually like to avoid. Now, as to the central question here, will Donald Trump go to trial on October 23rd? The final word on that rests with the judge, Scott McAfee, who is expected to make a decision very soon, perhaps as early as tomorrow. Joining me now is Chris Timmons. He's a former Deputy Chief Assistant District Attorney who has tried RICO cases in both DeKalb and Cobb County. Chris, thank you for being here to enlighten me as to what we should, setting our expectations, how to do it. Judge McAfee, what is your expectation about this case and 19 co-defendants going to trial together?
So there's some tension here, Alex. One of the things that I don't think a lot of people are talking about, but they need to keep in mind, is that this is an active courtroom. So he's probably got between 500 and 1,000 cases that are pending besides this very major case. Among those cases are going to be people who are currently in custody. There are people who are trying to get divorces. And so if this courtroom is tied up for 2 years as opposed to 1 year, that's going to cause a major backlog. That's the tension on the one side, which is the tension that says, let's try everybody together starting on October 23rd. The other tension is ineffective assistance of counsel, which is a standard here in Georgia as it is nationwide. And that is that if you have attorneys who are not properly prepared for trial, that's an appellate issue and could get the case reversed. So you certainly don't want to be the judge who gets reversed in one of the most high-profile cases in history. Those are really the two things that we're worrying about. The final thing that's kind of an issue is what's going on in federal court with Meadows. I understand we've got some orders that came down from the 11th Circuit today setting up a briefing schedule. The last thing in the world you want to do is have a jury picked, have issue joined, meaning jeopardy has attached for double jeopardy purposes, and then have the case removed to federal court, which could cause a double jeopardy issue. So all those things are in play, and all those things are things that Judge McAfee has asked about and will be talking about as the case moves forward.
Well, so, OK, reading between the lines there, I'm hearing there's a risk at moving the trial date to giving everybody an October 23rd trial date because their lawyers may not be prepared. And there's all kinds of judicial peril in not having attorneys who can later say, or counsel that can later claim, or defendants who can later claim counsel wasn't prepared. And secondly, in terms of the Meadows request, we're talking about removal to federal court. Judge McAfee has brought that up, saying there's this whole attempt to remove this to federal court. How's that going to intersect with everything we're doing here in state court? The fact is the 11th Circuit seems to be moving pretty fast on all that, doesn't it? Is it your sense that we'll have the whole question about whether any of these defendants can move to federal court and get out of Georgia state court, that's going to be resolved relatively soon?
Yeah, it looks like it, probably by mid-September or late September anyway. I think the last date on the scheduling order is the 28th. But yeah, it's moving lightning fast. I haven't seen the 11th Circuit move that fast before in any of the cases that I've dealt with. But we're in unusual circumstances. I think probably the 100 or so correspondents and contributors that have talked about this case have said the same thing over and over again. We're in uncharted waters. And so I think the 11th Circuit wants to give some direction to Judge McAfee to let him know whether or not to proceed forward. And I think that they're going to ultimately side with Judge Jones from the district court. I don't expect Mr. Meadows to get the ruling against him overturned. And so, but then the question is, okay, we're at September 28th. We get a ruling maybe by October 1st by the 11th Circuit. Are those 22 days enough time to let everybody know this is coming? But one other thing that you should consider, Alex, is that they've got time during jury selection. This jury selection is going to take forever, and to the extent that there's extensive discovery, they can be formulating a plan as to how they wish to defend this case, even while they're questioning the jurors and going through the voir dire process.
Just one more for you, Chris. In terms of the 19. When do we find out if anybody's flipped? At what point? The flipping, if it's happening, is happening now. Is that right?
It should be, yeah. I mean, I'm sure there are discussions that are going on behind the scenes to flip folks. And usually, Alex, what you want to do, if you look at an indictment, particularly in Georgia, the least important members of a criminal conspiracy are the names towards the end. And so what you typically want to do when you're flipping people, and I've flipped people all the time when I was a prosecutor, you start from the bottom and you work your way up like a carpet. And so you work your way towards the top. You very rarely want to flip someone towards the top. The interesting one, kind of the wild card here, if I was a prosecutor, I'd be looking at trying to flip Mark Meadows, because I think if anybody knows whether Donald Trump had said something along the lines of, hey, I know there wasn't voter fraud in Georgia, but I need to pursue this anyway, the person who probably would know that would be Mark Meadows. He'd have been at a lot of the meetings where that possibly could have come up. So that's the person I would be targeting if it were my case. But they may already have that evidence. They may be getting that from someone else. But that's the wild card in this case. That's the thing that the state really needs to prove, is that Donald Trump knew on some level that there was not voter fraud involved in Georgia, that it was a clean election.
Yeah, well, right now, Mark Meadows would really like to not have to go to court in Georgia State Court, so we'll see how that all ends up. Chris Timmons, a wealth of information on a subject that is complicated, like an elaborately woven carpet. A carpet filled with people ready to flip and all kinds of legal pretrial motions. Thank you for joining me tonight, Chris. Appreciate it.
Sure. Appreciated the opportunity for the imagery, Alex. Have a good night.
You're so welcome.